So good morning, everyone. This is 25 CV 016310. We're having our 120-day conference. Let me get my window open here. All right, Ms. Franklin, I'm going to start with you. Then, of course, I'll hear from Ms. Snyder. And if there's updates we need to get from Ms. Shoemaker, we'll get that as well. Ms. Franklin, I know we also have a contempt matter. Obviously, we're not going to get into that directly today, although the parents do need to be thoughtful and careful about complying with the terms of the present situation in terms of coordinating on medical care and respecting who's got final say under the current situation. Ms. Franklin, how are we doing with discovery?
We have some remaining discovery disputes, as I'm sure the court is aware from some filings. I filed a supplemental brief yesterday regarding what remains outstanding. The Snyders, both counsel Rachel Andrew represent Mr. Pugh, and yesterday afternoon they also filed a notice of discovery dispute. Then I subsequently filed a response to that. What I think makes sense, though, Your Honor, in this case is that we have a guardian working on her investigation. We were originally ordered to complete mediation before today, and the guardian, as well as myself and opposing counsel, agreed that that would not be productive use of anyone's time until after we had at least a preliminary oral report from Ms. Shoemaker. Ms. Shoemaker, and she can correct me if I'm wrong, had stated that she thought she could get us a preliminary oral report by September 15th. And our mediation was therefore, the deadline was extended for 60 days. So that brings me back to the discovery dispute, and I invite counsel and the guardian to chime in on my thoughts along that issue. I think that it is likely that the guardian report that we get in September could materially narrow the various discovery issues that are still outstanding. And so I think it makes sense, even though we've got things that are due that we can put a deadline in between now and then, that we are going to probably need a hearing on discovery, but it might not make sense to do that until after we hear from the guardian in September. And we may have, I just found out about this dispute yesterday afternoon from the respondent side. So we may be able to resolve some of those issues. And so what I'm suggesting is that we put a deadline in for responses to discovery by the end of the month or within 30 days or so. Have the meeting with the guardian on or before September 15th to get her report. And then after that, potentially have a hearing on the discovery issues that remain. Am I making any sense?
You are. As I'm hearing you, and Snyder's, trust me, I'll hear from you. There are discovery disputes in both directions.
Yes.
Some of those disputes could go away depending on what Ms. Shoemaker concludes. You all have decided to defer mediation. I don't know if Judge Kay said that was okay, or when you say it's been set 60 days out, that was just the lawyer setting it 60 days out, supposed to have happened by now, but I'm understanding, apparently I entered an order. Okay. So that's why it got set out, for extra good reasons. Regardless, what you were describing was mediation would occur after Ms. Shoemaker has done what she needs to do. And that makes sense. So that would mean then a final hearing, if one is needed because mediation doesn't work, would be sometime after mediation. So I followed the flow. I'll hear from Ms. Shoemaker in a minute, but it would help me if you could, at a very high level, not much detail at all, just give me an example of what you feel has not been produced to petitioner and what you've just learned respondent is saying hasn't been produced to their side.
Okay. There are multiple very specific interrogatories that address allegations that were very vague in the initial pleading, but have become more clear as we've exchanged pleadings, et cetera, throughout the course of this litigation. And from my client's perspective, it's important to get detailed responses, written responses to those interrogatories, because they are regarding claims that Mr. Pugh says were made by the child.
Okay, and you don't need to get more specific, but it sounds like it involves their relationship as opposed to a bank record, or it's not disclosure of documents so much as it is one side articulating their position on an issue.
Correct. And that's why I say, I think, well, partially correct. I say, I think with regard to those issues, claims that the children have said something, input from the guardian may resolve those issues.
Right. Okay.
But there are also documents, same thing. These are documents that exist that where records were made regarding conversations with the children. And again, those might also be addressed from my perspective by the guardian. Now,
okay.
with respect to what Mr.
What have you not produced, allegedly?
There are multiple interrogatories. There were, I think, 44 interrogatories that were propounded originally. And by a conservative count, Mr. Pugh's interrogatories reached well over 50, including subparts, discrete subparts, by the time you got to interrogatory number 33. My client just declined to respond past that because it was really closer to 80 plus interrogatories that we had already responded to by that point. They are seeking responses to the remaining interrogatories, which adds up to probably another 40 or 50 in the next 29 interrogatories that are enumerated. For example, the very first interrogatory has 7 discrete subparts. So number, so that kind of thing.
That's, thank you. It wasn't we're not giving this over. It was, I've done enough and I'm stopping and I'm not answering anymore.
Yes. And there is also, I think, a bit of a dispute about deposition notices that were served.
Are there depositions that have yet to occur?
Yes, there are depositions that have yet to occur. However, the notices themselves were deficient in multiple ways. There were missing subpoenas. There were some witnesses weren't even identified. There was no location. There was no Zoom link when it was said to be by Zoom. There was no proof of service. There was no witness fees tendered. I mean, there were multiple deficiencies in these purported deposition notices. For example, the one that was noticed to my client didn't have a location specified. Or
so did you then reach out to one of the Snyders to say, hey, I got the notice, where were you thinking this would happen?
I didn't do that actually, because Ms. Shoemaker did that prior to me doing it, and she didn't get a response. I was copied on that email. Ms. Shoemaker asked, okay, do you want me there and where's it going to be? And there was no response to that email. So
all right. Let me turn to Ms. Shoemaker very briefly. Good morning.
Good morning, Your Honor.
How much time do you need to complete your work?
Your Honor, I was estimating being done by the mid to late September. September 15th might be a little bit optimistic, especially I'm concerned about this motion for contempt that was filed yesterday regarding some medical final decision-making authority issues. But Your Honor, I'm still shooting for the end of September to be done with my investigation and give parties and give the attorneys oral feedback.
Okay. So what you would have at the end of September would be the ability to verbally share with the parties your conclusions. You wouldn't necessarily have the written report done yet, but you would be at the point to say, here's what I'm thinking.
Yes, Your Honor. Your Honor, and if I may, as I read your standing order, I don't do a written report unless both sides or one of the sides requests it.
Okay.
So they just need to let me know if I need to do a written report, and I'm sure they'll do that once I give the oral report.
Got it. Do you have a perspective, if it's even appropriate to offer one, about the wisdom of putting mediation after the parties hear from you?
Your Honor, they have already gone to mediation once, and that was before I was in the case. And so I think that in order for there to be any opportunity for mediation to be successful, they need my input.
Okay. I didn't realize that, or didn't remember there'd already been one that didn't work. So what would change would be getting information from you.
Yes, Your Honor.
Okay, great. Thank you so much. Snyders, do you agree with the basic framework that Ms. Franklin outlined, which is let Ms. Shoemaker finish her work, share it with you, which now I'm going to say is end of September rather than September 15th, mediate after that, and see what, I guess also decide before mediation, you can let me know your thoughts, whether we need to have a discovery conference or not, because Ms. Shoemaker's results may make some of the discovery issues go away.
Welcome, Your Honor. It's nice to see you on the family law bench. We are excited that you're here. I can answer that very quickly. We agree that Ms. Shoemaker's information and report would be very important to us in hopefully settling the case. We did notice discovery, depositions, etc., because we were ending the discovery time period, and we didn't want to run afoul of the court's order on completing discovery. So those have been entered. One of the problems with entering the discovery and deposition request is because Ms. Pugh refused to answer our questions in our interrogatories with her boyfriend's contact information, last names, and there are numerous of them that have come up in the time since they've been divorced, have been introduced to the children, and we wanted to depose those people. She refused to answer those questions. We deferred and allowed a deferral of the depositions, understanding that Ms. Shoemaker, who is such an experienced guardian, would ferret out that information. At Ms. Shoemaker's request, we also delayed depositions of the children's schools, etc., to allow her to complete her evaluation, and we fully support that. And so we do believe that her input could be very important, but at the same time, we wanted to preserve our right to the discovery that we really needed if it wasn't forthcoming, which is, it's not a financial case. It is a case about two parents doing what's best for their children. And so a very big part of what's best for their children, in my client's opinion, is the 6 or 7 boyfriends that's come in and out of the house, the engagement.
So we don't need to get into substance here. I just wanted to understand your view on the flow that we're going to set in place, the sequencing of events. It sounds like it would be helpful if I extended discovery so that people would be able to continue to propound it after you get the results from Ms. Shoemaker. Some things that you wanted to do, you may not need to do anymore, but some things that you agreed to hold off on, you should still be able to do on both sides. So it sounds like I ought to extend discovery. And then we need to see where things are. We may need to do a 120 plus X conference to see what's a realistic deadline for mediation and how much more discovery is needed after everyone has digested Ms. Shoemaker's results. Does that seem like a safe and productive way, Ms. Snyder, to proceed?
The only thing that I would say, Your Honor, is that we proceeded under the discovery rules and issued our request for discovery within the appropriate time. And it's not that I object to extending discovery, but we did what we needed to do within the appropriate time in the Civil Practice Act. And we have our discovery out there and what we need. And so I feel like that giving Ms. Pugh the ability now to have a reset and go do whatever you need to do would.
I see your point. It would be more that we extend the deadline to respond to discovery that has already been propounded.
Perfect. Yes, Your Honor.
Okay, I do need to push back a little bit because it sounds like when you say you complied with the Civil Practice Act, you sent out some deposition notices that said, hey, show up for a deposition. And that's all it said. And I don't know where I go. What, do I go to your office? You coming to me? Is it Zoom? So I would ask you to just double check that if you are seeking to depose witnesses, you let them know where and how long, and if they are entitled to reimbursement, et cetera, that your notice. I'm not saying they didn't. I'm not wading into the middle of it. But if Ms. Shoemaker also didn't get a response to, should I be there and where is this deposition going to happen? That says to me, maybe there was a piece missing. So I'm hearing you that, look, everyone's had a chance to propound discovery. We're missing responses, and it sounds like that's true in both directions. But I don't know that people had a chance to appear for their depositions if they weren't told where those would be. But it sounds like we'll hold off on some of that anyway until we get Ms. Shoemaker's conclusions.
Your Honor, may I add something to this?
Yes, ma'am.
Your Honor,
I believe that the deposition notices were. I believe the deposition notices did give the appropriate place and the time. I believe Ms. Shoemaker was notified of it because Ms. Shoemaker and I had conversations about her request that I extend the time period so that she could continue her investigation rather than putting these people immediately being deposed. And I agreed to that in specific circumstances. Some of the deposition notices could not be served correctly because Ms. Pugh refused to respond to our request for the last names, addresses, etc. of all these boyfriends. So
Okay. All right. I got it. I shouldn't have waded into it. That's not what we're doing today anyway. Ms. Shoemaker, what did you want to add?
Your Honor, just very briefly, Your Honor, and I know discovery is not my place, but I get the feeling that both sides are trying to use me as a tool for discovery, which doesn't make me feel comfortable.
Right.
However, that being said, a lot of these issues are with interrogatories because this is about custody and parenting time. So it's not like we're talking financial documents. And, they're like, well, you didn't fully respond to this interrogatory back and forth. And it actually kind of would be helpful for my investigation. And my suggestion is that both sides depose the other party and ask these questions under oath. And I would like to be there because I think it would be helpful because there are some co-parenting issues between the parties that I would like to hear what some of the responses are.
Got it.
I have no issue with that. I would just ask that we try to get that scheduled mutually. These previous depositions were scheduled without any communication with my office regarding availability, dates, etc. So to the extent that these these depositions are going to be scheduled of both parties. I think there needs to be some cooperation with regard to the dates and locations. And I also think, or I would ask that they be completed before September 15th so that we don't push back Ms. Shoemaker's ability to get us an oral report by the 30th.
Yep, no, that makes sense. Are both the Pughs local? Like the previous call, there was a Houston County situation and this and that. So it certainly we need to accommodate people's schedules. Everyone is busy, your clients, you, et cetera. Is everyone local?
Yes, and I would further request that I think a very good neutral place, both litigation wise and location wise, would be Ms. Shoemaker's office if she is willing to host us.
Yeah, that's fine. I have plenty of space.
All right.
Judge McBurney, if I could say that
Yes.
in 3 years, 4 years, whatever, I haven't taken a 2-week vacation, maybe into 6 years. And I'm going to be gone August 31st through the 18th of September. And again, it's the first vacation I've taken in many years of 35 practices years. And so I've asked that that be honored. I filed a notice of leave of absence. So that might be difficult for me to finish by. I can't.
Mr. Snyder could handle the depositions if he's not on leave.
So we'll work through it. Again, this is not, you got it. We will not interfere with your leave, Ms. Snyder. I'll note that it is August 6th. So there are a whole bunch of days left in August. I'll look at who has filed entries of appearance for the two parties, and we'll figure out how to make it happen. But I think that was a very helpful suggestion from Ms. Shoemaker that we take care of these things in that way. It gives her more information, which everyone should want, and it will necessarily address a number of the discovery disputes, all in one package. So thank you for that idea. All right.
Shoemaker had time this month to finish that. I didn't want to interfere with her investigation. That's all.
Okay, understood. Ms. Franklin, anything else we need to cover? Does it make sense to set a trial date? I have trial dates in November, and that seems far enough out that we could lock everyone into a trial date. Because if Ms. Shoemaker is done by end of September, not 9/15, but end of September, then, and a lot of these discovery disputes are addressed by way of depositions, which need to happen before she gives you her report, then all of a sudden we've got October for you to do whatever's left, and a trial date in November doesn't seem like a crazy idea. I worry if we don't set a trial date right now, I don't know, when are we going to get back together? So, Ms. Franklin, what are your thoughts about me locking that in as well?
I like the idea of having a final trial date locked in. Similar to Ms. Snyder, I've got some leave already in November, but I do have plenty of open days. I think this trial could be more than a day. But I'm out at the beginning and at the end, but I've got plenty of days in the middle of November that would be available.
Great, and we will honor everyone's leave that's already on the books, so don't worry about that. You're thinking bench trial 1 to 2 days? Is that what you were saying?
It's hard to say until we have some more information, both through the discovery process and from the guardian. But I would hesitate to limit it to 1 day this early out. I think I would say probably 2, and then maybe adjust it later.
Okay, it's always easier to adjust to shorter than longer. What about bench trial versus jury trial?
Bench trial.
All right, and Ms. Snyder, bench trial, we'll book it for now for 2 days. It can always be shortened. It's just harder to lengthen it.
Your Honor, I agree with the bench trial and I agree with the 2 days. I would ask Patty how she feels about it. But I believe if the time was divided equally, then as the defendant, I wouldn't want to be limited to 3 hours on a Tuesday afternoon after an hour and a half. So I would probably say 3 days, knowing we can back it up to 2 days if needed. And I would defer to Ms. Shoemaker.
Well, you've got a lot of control over this one, Ms. Shoemaker.
Yeah.
I'm going to book it as a 2-day trial. I can always find additional time if I need to. We have availability on November 16th as the day when we would start it. Does that work for you, Ms. Franklin? That should fit, sandwiched by your leave.
Yes, that works. Thank you.
All right, Ms. Snyder, you'll be well rested from your first vacation in 100 years. Does November 16th work for you?
I'm looking now, but yes, I will be I hope well rested. Yes. Thank you. It does.
Ms. Shoemaker, you don't need to be there the entire trial, but do you see that you would have some availability on the 16th?
Yes, Your Honor.
Great. Then we will lock that in and work backwards from there. The trial notice that goes out will have, well, I'll talk with Ms. Niles about whether we're going to do a separate order about discovery and depositions and whatnot, but we will address that as well. And I know there's a contempt piece hanging out there. We're not going to address it today, other than, again, my friendly reminder, if the evidence that gets presented to me is that someone is real clearly flouting who's the boss when it comes to scheduling medical things, that doesn't end well for the person who wasn't following the rules. Not saying anyone didn't, but we need to, in these in-between times, make things as smooth as possible for the kids. Ms. Franklin, anything else we need to cover from your client's side?
I want to make sure that we have the opportunity to be heard on the discovery issues if they still exist after the mediation, and we've got the guardian's report that there's a couple hours somewhere before the November 16th hearing that we can be heard on that, because
yes,
we need to get those resolved. Okay.
100%. The onus will be on the lawyers to reach out to Ms. Niles saying, we did the 2 depositions, we got the results from Ms. Shoemaker, we mediated, and there's still a discovery issue. But if you bring that to my attention, then we'll have a hearing on that.
And with respect to my client's motion for contempt, we are fine having that heard together with the final. I'm not asking for a separate hearing on that.
Oh, okay. So just weave that in with the hearing on the 16th.
Yes.
Okay. Thank you for letting us know that. We won't now try to slot it in somewhere else.
We got other important things to slot in. So,
okay.
I mean, not that that's not important, but it can be done all at once.
Okay. Ms. Snyder, anything else on behalf of your client, Mr. Pugh?
Yes, I don't believe any discovery dispute should be added in with a final hearing.
It's not. That's the contempt. Our speaker broke up, Your Honor, when that was.
Okay. No one's combining discovery disputes and contempt. All I said is that if after the 2 depositions, 2 clients, and Ms. Shoemaker's results and mediation, there are still outstanding discovery disputes. People feel like there were not complete answers. It's not new discovery. It's, hey, you didn't respond to interrogatory 14 or 35 through 80. I am happy to hear that dispute, but I don't want to mess with it before then, because to Ms. Shoemaker's point, a lot of that may go away through the depositions. And what the heck, maybe at mediation you resolve 90% of this issues, and we don't need to worry about the discovery piece. So all I said was, if you file something and bring to my attention that there remains a discovery issue after all those other things have happened, I will certainly hear it well in advance of November 16th, so that if someone is needing to disgorge something, they do it in a timely fashion. That's all. Okay? All right.
Your Honor.
You're welcome. Ms. Pugh, do you have any questions for me?
No, Your Honor.
All right, Mr. Pugh, any questions?
No, Your Honor, I'm good. Thank you.
All right, nice meeting all of you. Good luck with things. We'll get an order out soon that addresses all the many variables that are still out there. Thanks for your time.
Thank you, Judge.
Thank you.